Okay, it's a little bit after 9 o'clock. I think based on the number of name tags upstairs, the railway complexities are still causing some people to be late, but the show must go on. And so we'd like to get things started. My name is John Hallway. I'm the Executive Director of the Quattrone Center for the Fair Administration of Justice here at Penn Law. It is my huge honor and privilege to welcome you here for our second symposium, Defining Quality in Criminal Justice. To kick things off, first I'd like to introduce Wendell Pritchett, the Dean of the Penn Law School. Dr. Pritchett has been interim Dean of the Law School and a Presidential Professor at Penn since last July 2014. He previously served as a Penn Law Professor from 2001 to 2009 and then as Chancellor at the University of Rutgers-Camden from 2009 to 2014. Prior to his time at Rutgers-Camden, he was also the Deputy Chief of Staff and Director of Policy for Philadelphia Mayor Michael Nutter, who also appointed him to the School Reform Commission in Philadelphia, where he served from 2011 to 2014. As the Executive Director of a Criminal Justice Reform Center, I can tell you it's been a real pleasure having a dean who is so aware of urban policy and practice issues and community issues. Dr. Pritchett, his research examines the development of post-war urban policy and in particular urban renewal, housing finance, and housing discrimination. And he's taken a leadership role in numerous nonprofit organizations that the criminal justice reform process touches, including being the board chair of Community Legal Services in Philadelphia, president of the Philadelphia Housing Development Corporation, chair of the Redevelopment Authority of Philadelphia, and a member of the Pennsylvania State Planning Board. Please join me in welcoming Interim Dean Wendell Pritchett.
Good morning. Thanks, John, for that overly generous welcome. I really appreciate all of you coming here today for this important conversation. We couldn't be happier to welcome all of you to the University of Pennsylvania Law School. We've already started talking about the tragic accident that happened last night, and obviously we offer our condolences to the families of the 6 people that we already know of who have passed away and the others who are injured. It is a terrible occurrence, but we also know that traffic safety, transportation safety has improved greatly in this country over the past 50 years, 100 years, that we are much safer. And why are we safer? We are safer because we acknowledge that there were big problems in our transportation systems. And we made it a priority to investigate accidents. And then out of those accidents, we developed best practices and we enforced them both through informal and formal rules. And then we actually measured our progress and held ourselves accountable for what we were trying to do in that area, right? So why do I tell you all that? Well, one, you know all that. But I learned a whole lot of that last year at the first Quattrone Symposium. And so that's why it's so important that we have these kind of conversations, but it's also why it's important that we have the Quattrone Center and institutions like it, because we in the criminal justice area and the administration of justice area, as you know, haven't taken those approaches, right? We haven't actually acknowledged we have big problems and started to research what are best practices and then developed rules that we're going to actually hold ourselves accountable for in the future. Now, as you also know, we're getting a lot of attention to the criminal justice system right now. That's a problem, but that's also a good thing, right? In this opportunity, in this challenge, we have an opportunity to actually improve our systems. And so I know we have a great program today, and there are going to be lots of interesting discussions. And so I'm going to sit down so that we can actually get those started. But I did really want to thank you all for coming and emphasize, I hope I've emphasized in my brief remarks, how important this work is. I know you know, but I want to express appreciation to all of you for the work that you are going to do today and the implementation that you're going to pursue afterwards. Thanks again for being here, and I look forward to participating in the conversation.
The Quattrone Center was founded less than 2 years ago in August of 2013 as a national research and policy hub. And the expectation was that we would catalyze long-term structural improvements to the United States criminal justice system using an interdisciplinary, data-driven, scientific approach to identify and analyze the most crucial problems that the system is dealing with, proposing solutions that improve its fairness for the long-term benefit of society. Our research and programs are independent and unbiased, and we strive to engage all parties, academics, judges, law enforcement, defense and prosecution attorneys, legislators, social scientists, forensic scientists, the media, and others, that are required to effect change for the better. As Wendell alluded to when he was stealing my remarks about the train accident, the Quattrone Center has advocated since its inception for what we call a systems approach to criminal justice reform. And what we mean by that is that historically criminal justice has attempted to reform itself through litigation. And litigation can be an excellent way to redress a known injury and sometimes to force a change, but in general it's a poor tool for preventing the next injury or for helping people collaborate together to solve systemic problems. And so the Quattrone Center, at its inception, started looking outside to other complex systems that we believe had similar characteristics to criminal justice, systems that were high risk, high tension, zero tolerance for error, dynamic environments where good faith professionals were forced to make difficult decisions with far-ranging consequences using incomplete information. And we wanted to see if principles that those industries, such as healthcare or aviation or nuclear power, had used to make themselves high-quality, high-reliability organizations could be applied to criminal justice. And there are a couple of principles that I think those industries have embraced that are important in coloring the conversations we're going to have today. So first, those organizations start from the expectation that while there are the occasional bad apples, there is the occasional person who does something intentionally wrong. And in an aviation context, the tragedy of the German pilot who decided to take over the cockpit and crash the plane strikes me as one of these examples. That those people do exist and we need to have a process for dealing with that, but that those people are not the source of the vast majority of the errors and challenges that we have in these industries, and that's true in criminal justice as well. That approaching this as a bad apple problem is not going to bring people together and allow us to get the mass and the scale we need of participation to address these problems, and that rather what's necessary is to bring all participants in the system together to understand why these good faith professionals working hard at their jobs, all of whom want the right thing to happen in criminal justice, nevertheless are making decisions that lead to unwanted outcomes, adverse events, errors, and mistakes. And therefore that a collaborative approach to error reduction is necessary to effect change. So it's in that spirit of collaboration that we've gathered all of the speakers that you'll be hearing from today, because we have a goal that is at once very simple and extraordinarily elusive, and that is to define what high quality is, what quality means in criminal justice. We know when we talk about criminal justice and about quality that everybody has their role. In a sense, we understand the high-level roles that each of our agencies are supposed to play. We know that police are supposed to keep us safe and be protectors of our community. We know that prosecutors don't just want to convict people, they want to be ministers of justice. We know that defense attorneys want to preserve our constitutional rights, that they want to hold the state accountable to its appropriate burden of proof, and that judges want to ensure that the entire adjudicative process is fair and efficient. But we'll hear later on from a woman named Amy Bach at Measures for Justice who said something that I thought was very poignant. She said, you know, we all know what the high-quality hospitals are in our jurisdiction, and we all know what the high-quality schools are in our jurisdiction because we have rules for defining quality in those settings. Can any of us decide or define what the high-quality criminal justice agencies are in our jurisdiction or the next jurisdiction? How do we define what high quality is? If you got a defense attorney tomorrow, how would you know if he was a high-quality defense attorney or came from a high-quality agency? And those definitions and metrics and measurements are very, very hard to manage. Now again, if we take a systems approach and take a step back, let's consider how quality is defined in industrial management. The International Organization on Standardization, ISO 9000 standard, defines quality as basically a two-pronged test. Lawyers love two-pronged tests. The two-pronged test for quality is essentially one, quality is specification driven. So the question is whether your system is accurately, reliably, and consistently achieving its set goals. But there's a second measurement of quality, and that measure is essentially one of customer satisfaction. Do our customers, our communities, agree at the outset what the goals of the system are, and are they in agreement with what comes out at the end of the process? Do we agree that when we've got a completed case, an adjudicated case, we agree with that outcome? And you can measure quality according to ISO 9000 based on the number of rejections that you get from the customers who are the recipients of whatever the object of quality is. So reliable, accurate, and consistent in achieving its goals, and accepted by customers are our two requirements for a high-quality system. And you could say that based on that definition, in some sense, we're making progress in criminal justice because we're reducing crime. Over the course of the past 2 decades, according to the Uniform Crime Report, both property crime and violent crime are down about 30% at a time when the US population has gone up about 20%. So that's clearly a very good thing, and maybe in terms of the specifications of the criminal justice system in reducing crime, perhaps we are developing or increasing the quality of that system. It's on the other side, quality as meeting the specifications of its customers, however, that we see a very, very different picture. The fact of the matter is the criminal justice system has 2 goals: reduce crime, but in the doing, it's essential that we get the right guy in the right way. In other words, hold the perpetrators of crime appropriately accountable for their actions, but do so in a way that protects the constitutional freedoms of everybody involved, including the people caught in the net of investigation, arrest, incarceration, and conviction, and imprisonment. And the fact of the matter is, I don't think anybody would say that we don't get it right the vast majority of the time. Whatever our error rate is in criminal justice, no one is suggesting we are more than half wrong. Nobody's even suggesting we're more than 10% wrong. But of course, that isn't the bar. Lucian Leap, who spoke here last year, has pointed out that in other industries, a 99.9% safety and accuracy rate is not good enough. If we applied a 99.9% accuracy rate to other industries, we'd have 2 unsafe landings per day at O'Hare Airport alone. We'd have 16,000 pieces of lost mail every hour. And in the US financial system, we'd have 32,000 deductions from the wrong bank account every hour. So there are lots of other industries that aren't dealing with individuals' lives and civil rights, where 99.9% success rate isn't acceptable, and criminal justice, I think, is no exception. There were 125 new exonerations in the National Registry of Exonerations last year. That's about 1 every 3 days. And that pace is accelerating, not decelerating. In addition, if we were 99.9% accurate, and by the way, we have no idea if we are or not, which is a fundamental problem, but even if we were, that would mean we would be making errors in 27 criminal cases per day, or about 10,000 felonies a year. Now, to the credit of our criminal justice professionals, I think they all understand and in fact embrace the fact that perfection, and not 99.9%, not the ivory soap purity test, that perfection is the goal. And I salute all of the criminal justice professionals that are going to speak here today and their colleagues for relishing a challenge of perfection in long hours, limited resources, with unforgiving circumstances. But our communities are still not satisfied with the service they are getting, so they are rejecting the premise that our criminal justice system is high quality. We need to know with confidence that our agencies are getting the right guy in the right way every time. And when we make a mistake, the deny and defend culture that every agency that has looked at this problem has had to transcend is no different in criminal justice. But deny and defend sacrifices long-term safety gains in a system for the potential of a short-term political gain. And when we see Ferguson and Baltimore and New York and the crime lab scandals with the FBI and San Francisco and the District of Columbia, what we're seeing is now even that short-term gain in deny and defend is being rejected by our communities and needs to be dealt with. The perception of the trustworthiness and legitimacy of these agencies is very low, and the way we do what we do has too many errors. And this is not limited to the police by any means. I mean, ask Robert McCulloch, the DA of Ferguson, or Mike Nifong or Ken Armstrong. Clearly, those are not high-quality prosecutors. You can ask defense attorneys with the increasing spate of ineffective assistance of counsel, or the judges in Pennsylvania who are part of the Kids for Cash scandal. These errors are traumatizing the legitimacy of all of our agencies all the way through the system. And as we challenge the legitimacy of these criminal justice professionals, what becomes clear is that the definition of quality is necessary to defend against that. Because when we lack a vocabulary about what quality is in the system, we lack the ability to identify where quality exists and where we need to build to attain more quality. And what that means is a scandal in Ferguson taints the Philadelphia Police Department. A scandal in the San Francisco crime lab taints the Miami crime lab, because we have no way to differentiate whether something that's going on in San Francisco isn't going on in Miami, other than to have the people in Miami say, that'll never happen here. And so the conversation that we're going to start here today is vital, because without that vocabulary, scandals anywhere tarnishes legitimacy everywhere. So that's what we're here for today, is to begin the process of defining the definitions of quality in criminal justice. And so, again, as being a research and policy hub, we've gathered an interdisciplinary set of experts who we think are capable of having that conversation. And I gotta say, as impressed as I am with the people we've assembled, I'm even more impressed with those of you in the audience, because I've read the RSVPs, and it's really encouraging to see how many thoughtful criminal justice professionals and thought leaders we have here in the audience today. We've constructed the day to allow for dialogue among the speakers, but also to have large parts of the conversation where the audience will participate as well. And so what I would encourage all of you to do is to participate early and often, because it's only through the interaction of good faith professionals that we can learn about the underlying realities and the concerns that other parts of the system have. And we term these other parts of the system adversarial, but the fact of the matter is, if we don't understand how the other parts of the system are working and what motivates them to act, we won't be able to construct solutions that span the silos of those agencies and really improve the fair and impartial administration of justice throughout the system. So today we're going to have 5 segments. We're going to start with a keynote, and I'll be thrilled to introduce Mark Moore as our keynote speaker in just a moment. We will have 3 discussion groups. If you are high-minded, you will think of these discussion groups as maybe being in a McNeil-Lehrer format. If you watch the kind of TV I do, this will be more like ESPN's The Sports Reporters. But the idea is to have our experts talking in a free dialogue among themselves so that we can begin to tease out both qualitative and quantitative concepts of quality. And then about halfway through each discussion group, we're going to open it up to the group, and we're going to allow each of you to tell us what you think of quality because of that second part of the ISO 9000 standard, that customer satisfaction part. And so please do participate as we try and figure out how we know if our jurisdiction is high quality, how we can compare one jurisdiction to another and see which are the bright spots and which need help, and what high quality means in our courts, prosecutors, and defense attorneys. So with that, it is my distinct pleasure to introduce Professor Mark Moore from the Harvard Kennedy School. Mark is probably the foremost expert on defining what the public value of a government or nonprofit organization is. And one of the ways that you get to be known as the world's foremost expert is you actually coined the term yourself. So Mark actually coined the term public value in his book, Creating Public Value, and he's expanded on it in his book, Recognizing Public Value, which I can really commend to you. In particular, he did a chapter on the Massachusetts Department of Social Services that really helped crystallize the approach that the Quattrone Center wanted to take to criminal justice reform. Professor Moore is the Hauser Professor of Nonprofit Organizations at the Kennedy School, but prior to that, from 1979 to 2004, he was the Guggenheim Professor and Faculty Chairman of the Program of Criminal Justice Policy and Management at the Kennedy School. His publications include Creating Public Value, Strategic Management in Government, Dangerous Offenders, The Elusive Targets of Justice, and From Children to Citizens, The Mandate for Juvenile Justice. And his research focus has been on how leaders of public organizations can engage communities in supporting and legitimizing their work and in the role that value commitments play in enabling leadership in public center enterprises. He has a BA from Yale, summa cum laude, with exceptional distinction in political science and economics, a master's in public policy, and a PhD from the Kennedy School of Government at Harvard University. I can't think of anybody else who's better to start the day off for the topic that we want to have, and I'm thrilled to introduce Professor Mark Moore.
So I was driving into Philadelphia from the airport yesterday, and it was suddenly nice to be back in Philadelphia. I had spent some portion of my life in Abington, just a little north of here. But my most recent recollections of Philadelphia were a time about 20 years ago when I was serving on a special commission to review the operations of the Philadelphia Police Department. And Kevin Tucker was then the incoming police commissioner, and he invited me and some other people to serve on a commission. And the reason we had the commission was that this was at a time when a corruption scandal had developed in the police department, reaching to the level of the deputy commissioner or superintendent. And they had just carried out the MOVE operation. I don't know whether you remember that or not, but it was this idea where there was a group of, quote, radical people in a particular house, and they wanted to arrest them, and so they dropped a smoke bomb into the house, and it burned down a city block and killed many people, right? So this was a department that seemed like it was on its knees and was sort of in the public sector version of bankruptcy, and they, as they often do, they created this commission to try to turn the trend in a different direction and see how to make improvements from what was a disastrous situation. And the people on the commission were smart enough to know that filing a report wasn't going to do much. And the important question was, how could we create and sustain a external public constituency demanding important reforms in the police department in Philadelphia? And so to get the ball started on that, we commissioned a survey of citizens on what their view, as John suggests, as customers, what their view of the situation was. Now, at that time, I wasn't smart enough to know that I had to think about the police department as having three quite distinct customers, all right? And customer number one, of course, was the person who called the police and needed help. Customer number two was the person who might be stopped or cited or arrested by the police. And customer number three was a citizen or taxpayer who was overseeing the aggregate operation and evaluating it not from his individual service point of view, but rather from the point of view of somebody who was paying taxes or authorizing the police to act in his or her name, and who wanted to know whether the police were behaving efficiently and effectively and legitimately or not. And this distinction, I think, between what I'll call citizens, voters, and taxpayers on the one hand, and client beneficiaries on the second, and then the third, client obligatees, is a very important distinction in the theory that I've tried to develop about the strategic management of public sector organizations. And of course, it's difficult to distinguish among those people because often they're the same people. There are many people who have called the police and also been arrested by the police and paid taxes to support the police, all right? So there's this interesting question about whether one could reasonably distinguish customers, reasonably distinguish among these people. And I should tell you that among the most invincibly ignorant people in the world are Harvard professors, all right? And the reason they're invincibly ignorant is they've got so much stuff in their head already that there's not a lot of room. And they spend so much time with their mouth open that there's not a lot of chance to hear other things. And noting that these groups were different, that the citizen obligate, or the client obligatee, the client beneficiary, and the citizen taxpayer were the same people, would have ordinarily prevented a reasonable person from pursuing the line of thought any further of trying to maintain that distinction. But being invincibly ignorant, I decided that I had to press ahead and maintain that distinction. And so what I developed was the idea that these different, quote, customers were the same people with different tapes playing in their head at a particular moment in time, that somehow or other it was, we're not very well integrated people, and depending upon the context, we could be thinking of ourselves either as a citizen and taxpayer, or as a client beneficiary, or as a client obligatee. And just to make this idea plausible, think of yourself going to the Registry of Motor Vehicles in Massachusetts. Now, I don't know whether you have the same problem in Philadelphia, but going to the Registry of Motor Vehicles in Massachusetts is a horrible experience. You go to a crummy old building in a bad part of town, and it's hot and it's crowded, and the lights are dangling from the ceilings with naked wires and stuff like that. And you have to come up, and there's a huge crowd of people, and beyond them is a group of people in cages, and you elbow your way through the crowd to get to the people in cages, and you finally get there and you say, I'm here to register my car. And the person in the cage says, that's fine, sir. Do you have form 4836? And you say, oh, geez, I left form 4836 at home. Do you have another one? Oh, no, I'm sorry, sir. We ran out this morning. Oh, dear, it's lunchtime. And down goes the counter, all right? Now, if you're thinking, what's your usual reaction to that would be, goddamn government failing to deliver services, right? So you come back the next year, and they've got the customer service idea. Incidentally, the only reason I'm there is that I'm obligated to get my car license. It's something I don't particularly want to do, but I'm there because I'm obligated. So I go back the next year, and it's a brand new building, nice part of town. Air conditioning is working perfectly. The air is ionized. I can smell coffee brewing in the background. There are potted palms. There's a woman at the front holding a sheaf of half-filled out forms in case I might have forgotten one of mine. And behind her, there are 3 people beckoning to me, hoping I might come to their stall to relieve the tedium of their day. And of course, my reaction then is what? Goddamn government wasting my tax dollars, all right? And so the point here is that you can move instantaneously from one of these perspectives to another, and the question then of whether we are getting acceptance or not from people depends a little bit on whether the acceptance we're interested in is the satisfaction of the person who's asking for service, or the satisfaction of the person who's being obligated, or the individual citizen who has gathered together with other citizens, perhaps in some kind of public forum, to decide what would be the qualities that they would like to have in their criminal justice system. So, going back to the original story, we set out a survey to what we hoped would be citizens of Philadelphia, asking them what they thought of the performance of the police department. And we asked them, how many of you think the police department is rude? All right? Nearly everyone thought they were rude. All right? Next question, how many of you think the police department sleeps on the job? Oh, mostly everybody thought they slept on the job. Next question, how many of you think the police take bribes? Fully 2/3 of the people thought that the police were taking bribes, right? How many of you think the police department sexually harasses defendants, right? About 1/3 of the people thought that the police department did that. And then we came to the crushing question, which we hoped would give us the energy for driving things forward. And we said on a scale of 1 to 5, where 1 is bad and 5 is good, how would you rate the police department? And the answer came back 4.4. Right? I was completely stunned by this, and I was discussing, we'll get to the Philadelphia part now, I was discussing these survey results with a group of captains from the Philadelphia Police Department, and they were staring at the numbers, and they were all kind of staring at their feet, and I was saying to them, well, what do you guys make of this? I mean, this doesn't seem to make any sense. And they all kind of going like this, and finally one of them took pity on me and decided it was time that I understood the facts of the situation. And so he looked at me and he said, look, Doc, he said, when you're shoveling society's shit, you got to be indulged a little bit. And I thought to myself, holy smoke, that's one definition of quality. And I thought to myself, how in the world did he get the idea that that was what the citizens of Philadelphia wanted from their police department? And to the degree that that remained an idea of quality, what could the rest of us do to actually achieve quality, all right? And so I think that starting this discussion about quality, it's tempting to start from the point of view of people who were in the middle of the machine, trained professionals, adjudicating cases according to rules of law, all right? And that's what we'll spend most of our time concentrating on today. But then there's this other piece that has to do with the legislature that decides what acts are going to be given criminal liability. And then there's this far wider piece which has to do with a general public deliberation and a general public culture that says, that defines quality and creates the context in which all of the other people do their work. And in that, there's the question about the degree to which that little piece in the middle there, guided by the law and manned by professionals, can actually be relied upon to do its work in the context of a lot of the other things that's going on. I'm going to push all that other stuff aside for the most of the talk today and concentrate on the narrow piece of criminal justice case processing, but I think we ought to have in the back of our mind the even broader question of what a just criminal justice system would look like in an unjust world where people are not paying all that much attention to the values that are daily being realized through the operations of the criminal justice system. So my talk for today is this talk on the pursuit of perfect justice, improving quality in criminal case processing. And I think the idea of perfect justice, just to fix our conceptions, has roughly this idea that each individual in the society gets their due. And that then implicates this question about whether we've constructed a set of laws that distribute criminal liability appropriately across acts as a just one, whether we've defined the facts necessary to find criminal liability with respect to each of those, so that we've set up a legal structure that reminds us all and causes us to work for developing the essential elements of a case. And then the last point, which is that the relevant facts specified by the definition of the law and the elements of the crime are comprehensively and objectively developed to the best of our ability, so that the judgments we make about whether a case does or does not meet the standard of criminal culpability is in fact realized. So now, the reality, of course, is that we have something that could be called rough justice. And in that reality of rough justice, many people don't get their due. And sometimes they don't get their due as each person to the party sees it. The offender was always a little bit treated harshly, the victim wasn't satisfied, etc. But then it could also be as all the rest of us citizens see it, about whether people got what was due to them, and then as the legal system sees what is, whether people got their due. And again, I want to emphasize the fact that there are these different judges, if you will, or arbiters of whether justice was done or not. And the first part are victims and witnesses, the second part is all of us folks, and the third part is the justice professionals acting on our behalf to see that a legal definition of justice, the way they understand it, is being done. So the reality occurs partly because we get it wrong in terms of constructing legal liability, and we don't have a perfect system for bringing cases into court, so some significant injustice is introduced at that stage. But it's also a problem in how cases are processed through courts in the adjudication of guilt and innocence. As I say, I think it's that one that I want to concentrate on today, since we mostly have in the room prosecutors, defense attorneys, and judicial people. If we had police in the room, we'd have another discussion of justice. If we had correctional officials in the room, we'd have still another discussion of the ideal of perfect justice. But for now, we're going to concentrate on the justice that happens in our courtrooms when a case has been brought against a suspect. And the way we've tried to legitimate rough justice that we know we have to live with is we say to people, trust the process. And to a great degree, that works. And it works particularly well for legal people, because in their heart of hearts, the people that are involved in the legal process know that in the end, they don't have much to fall back on other than the degree to which they fulfilled the process requirements of the system. And they don't actually have a good sense of whether the process requirements of the system are actually producing what we'll come to call substantive accuracy in the determination of cases or not. It's sort of the best they can do. And that has turned out to be a concept that has allowed the legal profession to go on even in the face of a large gap between perfect justice and the justice that we're able to produce. But what I worry about is that if we rely only on what we'll come to call procedural justice, then the desire to improve the process, to understand the properties of the process that we're working on, and to define quality and seek to produce it in a different way is stalled, because we're comfortable with the idea that, well, we've got a process, we've lived with it for a long time, everybody has to get used to it, I'm sorry, it's the best we can do. And if it's not the best we can do, then there ought to be a huge amount of urgency in trying to improve the process. And in order to do that, we'd have to understand and pursue the underlying public values that we want to achieve by and have reflected in criminal justice case processing. So the first moment here then is to sort of try to get clear about what the important values are that this particular system that we've constructed is designed to advance and protect and secure for all of us. Now, I've introduced here a little table that's called the important public values at stake in the operations of the criminal justice system. I should say I've done it in the context of the criminal justice, but this little framework works for many public sector activities. And it begins with the left-hand column there. There are two different philosophical systems that are represented on this chart. And the column on the left is called utilitarianism, and it's principally concerned about the good, and it judges actions as good in terms of whether they produce good consequences, where the good is valued principally in terms of individual welfare to a particular person or individual welfare summed over a whole society. So those are the utilitarian values that are associated with the good. There are these other values that are called, in philosophy, this is a terrible word, nobody in philosophy likes it, which is deontological values, where we're concerned mostly about the just and the fair rather than the good. And this sort of divides the world in an important way. And one way to understand what deontological values are about is that they judge actions in terms of whether the actions were consistent with our rights and responsibilities with respect to our rights and responsibilities that we have for others, and the degree to which we have lived in a system of right relationships that exist in the society. So the first is interested in ends and means and mere material welfare. The second is concerned about rights and obligations and duties and right relationships in the larger society. Now, some people looking at this, they think of the stuff on the right as moral and ethical duties, and the stuff on the left as practical concerns. But it's important to understand that the practical concerns, the utilitarian stuff, are values as well, that's a philosophical system, that if you're a public manager deploying the authority and money of the state, you have a duty to try to use those assets, money and authority, as efficiently and effectively as possible, as well as justly and fairly. And you would have heard in John's speech as he was going through a rather frequent move back and forth between what you could be described as deontological values and utilitarian values, with the deontological values showing up whenever he talked about justice and fairness and rights and stuff like that, and the utilitarian values showing up every time he talked about what would be good or what would be efficient and effective and stuff like that. So these different value systems are at play in our world, and they are part of the way in which each individual, the professionals, the legislators, and the citizens and taxpayers, and the clients all view what's happening in the criminal justice system. They move back and forth, not only among those roles, but also in associating themselves and trying to advance these different kinds of values. The next thing to understand is that these values could be experienced and judged at the individual level, and that's where the idea of a customer comes in often, because a liberal society likes to satisfy individuals. It's a little suspect of the idea that a collective could arise and become articulate about its purposes. That sounds like socialism or communism or something like that, so they don't like to talk about that very much. And then in the utilitarian world and criminal justice, that would mean that we made the victims satisfied. They thought that what had happened was okay. And we also reconciled the offenders to their fate. They thought what had happened to them was okay. And so we're judging the satisfaction of individuals caught up in the criminal justice system, either as victims or as offenders. Then we go to the experience and judged at the social level, and here comes the familiar language of, well, the criminal justice system is working well because we reduced crime and recidivism, and we did so with less use of public money, and ideally also with less use of public authority, but that doesn't always come into the calculation. So the utilitarian values are viewed at the individual level. Was it good for everybody? And also at the social level, did we as an aggregate society get attractive aggregate results in terms of reduced crime at lower cost? That's the left-hand column. The right-hand column sort of says, again, these things can be viewed at the individual level and at the social level. At the individual level, the victim says, do I feel like my rights and do I feel like I was treated fairly? Did I get what I was entitled to from the criminal justice system? And the offender could also be asked the same question, whether he felt as though his rights were protected. And notice that what's interesting about that cell, of course, is that each person in a democracy is entitled to have their own view about what they're entitled to, all right? They can have a view about that and use that for deciding whether they were justly and fairly treated or not. But the rest of us don't necessarily have to go along with that, all right? And in fact, the whole purpose of the law is to essentially say, whatever your view is of what's right and just and fair, we have a view and it's this, and under that set of rules, this is what you get. And so that's what so when we go to the social level, the deontological values have to do with the reliability with which offenders are called to account, individual rights protected, and just relationships in the society either restored or protected going forward in the future. And by just relationships here, I mean not only between the victim and the offender, and the victim and the society, and the offender and the society, but the society and all of the individuals as well. Okay. So again, going back here, many people looking at this, the common way that people think about this is they say, well, oh, I get it. This is the distinction between practical values to be realized and constraints on the practical use of public money and authority to accomplish these goals, right? So justice is a constraint on our practical desires to achieve practical goals like reducing crime. But I don't think that's the best way to see it. And the reason I don't is because I think justice can often be fitted into, and this is particularly important for our conversation here, as a goal that is to be achieved through an instrumental calculation about how to run the system better, all right? So we take justice as a valued end in itself, and we ask ourselves the question, how could we best use the money and authority of the state to produce justice, right? Now that has the form of a utilitarian calculation. We're trying to use an asset called money and authority to accomplish a purpose. But our purpose is not necessarily a utilitarian value. It's a value that has to do with realizing an image of what is justice and what constitutes right relationships. And justice is something that can be improved through technical means. Now this is a very big deal because if you think that the claim that something is just is built on long tradition, and the best way to assure justice is to sustain long tradition and to be suspicious of technical improvements of any kind, then the idea that we could actually improve justice by bringing in some technical improvements will sound very odd to you, right? But on the other hand, if we think of justice as a state that we would like, as a condition that we would like to create for individuals and the society as a whole, and technical means become available to us for accomplishing that goal, then the idea that we could advance the cause of justice, we use that language commonly, through the appropriate adoption of those technical means would be an important way to do things. And then justice is something that can be instrumentally important in improving the efficiency and effectiveness of the system. Now this one was a really big deal in policing because what this says is that if the system that we're now operating, that the professionals are now producing, turns out to be good for beneficiaries and obligatees, and if it turns out to be judged good by citizens and taxpayers as well, then it might turn out that the citizens and taxpayers will reward the agency with additional funds, and it might turn out that they'll reward the agency with something even more valuable than that, which would be their active participation in the efforts to construct justice, right? So if we essentially could, so then being just could be not only valuable in itself, but also something that would be instrumentally important in accomplishing the practical objectives of the system, which would be to reduce crime at a relatively low cost, right? So what I'm trying to get to you to think about here is that these different ethical systems are interweaved with one another in a complicated way. And the reason I want to do that is because I wish to avoid a situation that commonly occurs when we see new technology challenging traditions in criminal justice, which is, well, we don't do it that way, and we don't trust it, and we can't see exactly how we're going to make improvements. Well, as long as that view is there, then it's going to be very hard to find a way to move from what has to be acknowledged as a rough justice system to a more perfect justice system. Now, having talked about this far, I need to introduce a new subject, which was prominent in John's talk, which was an idea that I'm going to describe as substantive accuracy in the adjudication of cases. And what I mean by substantive accuracy here is the ability to accurately distinguish between guilty and innocent defendants. And this is obviously important to justice because if we can't accurately identify who's guilty and who's innocent, then we're going to make errors of two types. An error of type 1 is that we're going to falsely convict a person who is in fact innocent. An error of type 2 is we're going to falsely release an offender who was in fact guilty. And these things turn out to be important not only to the justice of the system, because each of those errors in accuracy represents a kind of injustice, one probably more important than the other, but both quite important. But these are also important to the efficiency and effectiveness of the system, because if we can't accurately distinguish offenders from guilty people from less guilty people, then the mechanisms that we rely on, such as deterrence and incapacitation and rehabilitation, to link the criminal justice system to the reduction of crime won't work. So I want to demonstrate for you the challenge of producing substantive accuracy in the criminal justice system. And this may be the area in which the field of criminal justice is quite a bit different than the field of medicine and nuclear power plants and safety is true. But we might nonetheless use those as metaphors to help us understand and to see whether we can make an improvement. And the first is that the idea of guilt or innocence may be an incoherent concept. That is, for many people, the idea that there is a perfect justice that is realized when the system invariably identifies and distinguishes guilt from innocence is a pipe dream, that it's impossible at the technical level, and we have to doubt our ability to, about our moral imagination as well as our technical ability to establish facts. And so all we can say, going back to the usual litany, is that you were adjudicated guilty on the basis of a process that we've recognized for a long time. And the fact of the matter is we don't know and cannot imagine a way we could determine whether you were in fact guilty or not. Does that make sense to you? The second is that it could be a coherent concept, but we might be unable to reach it due to, and this is the big deal, an imperfect correlation between a case understood as a collection of facts that we have available to us in the criminal justice system on the one hand, and the underlying actual guilt or innocence of the offender. Now at this stage, I need to go to the board because I wasn't good enough with PowerPoint stuff. But I want to illustrate an idea. And I want you to imagine starting, can you hear me okay? Yes. So imagine that there's a continuum here. And the continuum is in some sense a measure of the strength and direction of a case. So at this end we have it, the case is exculpatory. At this end it is condemning, or whatever word you want it, strong proof of guilt. Someplace in the middle here is a weak case for prosecution. Probably here is a level that prosecutors should give the case back and refuse to prosecute. Someplace out here is a strong case. And sort of right here maybe is what we might call beyond a reasonable doubt, which is the standard we set for adjudicating guilt or innocence, right? So this is the idea that we're looking, all we get to look at as criminal justice professionals and as citizens sitting on juries and stuff like that is the case. And when we look at the case, the assembly of facts relative to the elements of the crime, we could in principle assess the strength of that case along that continuum, all right? Does that make sense to you so far? Okay. Now, this is the tough part to get used to. Now let's imagine that we actually have 1,000 cases in front of us, and we know two things about it. One is we know actually what the strength of the case looked like, right, as it presented itself. And the second thing is we know whether the person was actually innocent or not, okay? So now I'm going to show you the distribution of the scores on this strength of case for a group that was actually innocent, right? Let's imagine that the case is pretty good and we've got a distribution that looks sort of like that, where the green are the actually innocent people. So the actually innocent people, for the most part, had cases that were exculpatory or were weak, and only a few that were strong, right? Despite the fact that they were innocent, right? So it's hard to, what you have to imagine for a minute is that we could have a strong case against somebody who turned out to be innocent. And I suspect many of you have seen situations like that, right? But notice that if this is, in fact, the underlying distribution of the way the cases against innocent people actually look, we could, and we use this as the standard to decide guilt or innocence, we won't make any errors in the form of finding innocent people guilty, because all the cases will be below that threshold, right? Now that would be a very good world in which to live, all right? Now, now let's imagine though what the distribution of cases look like for those who are guilty, and let's imagine that, it's really hard to get a completely certain case here. It's a little bit easier to get this, but we have something that looks like this, all right, for the distribution. So these are the guilty individuals, and their cases were distributed along this way. These are the innocent people, and their cases were distributed along this way. Now, if that's in fact the way things are, and we use this as the standard for finding guilt or innocence, we will properly find this many people guilty, right? But we will falsely identify this group of guilty people as innocent. Does that make sense to you? So we've made, in this particular, if the world is like it is in this diagram, we will be following the usual injunction that sort of says, all other things being equal, we'd like to set a, we'd rather make an error of letting a guilty person go free than convicting an innocent person, and that would work like that, okay? So this isn't a terrible world to live in. We feel, who's mad about this world? This world. The victims are mad because they're standing here saying, how come my guy didn't get convicted? And the other person that's guilty is the person, the citizen and taxpayer and voter that's standing there saying, we got too much constraint in the criminal justice system, and we really ought to lower the burden of proof, because if we did that, we could get more of the bad guys in jail, right? And we'd only have to lock up a few innocent people to get the job done, right? So let's do that, right? So you could think of those as people being people who are rabid on crime control and wanted to make sure that everybody who was a crook did time, but were not very sensitive or very interested in the idea of going to jail if you were an innocent person. Does that make sense to you, everybody? And of course, but the situation could actually be much worse than this. I guess we don't have a eraser here. What if it turned out that the innocent thing looked more like this? Then what would happen? Then we would be treating this group of people over here, even though we have a high standard of proof, we'd still be putting innocent people in jail, all right? Now, the fact of the matter is we don't know which of these worlds we live in, all right? And notice that there are two parts of this world that we can manipulate. One part of the world is that we can move this criteria up or down. But if we have these overlapping distributions, what happens then as we move this standard up and down is that we don't reduce the number of errors, we just change the type of error we make. Is everyone clear about that? And that's a pretty tough world to be in when you're choosing among different types of errors, all right? But the other thing is suppose we got really good at building cases in a way that more reliably discriminated between the guilty and the innocent. And if we had a situation where the actual world looked like this, the innocent looked like that, and the guilty looked like that, then we'd be home free because we wouldn't be making any errors at all right? So that the critical question might not be, do we shift that standard, but how do we improve our ability to get substantive accuracy and consistency out of the actual process of developing cases as though it were a challenge not only to protect people's rights, but also to get substantive accuracy in what it is that we're doing, and where we would have to distinguish between the two, as difficult as that might be to a proceduralist to think about. So a lot of times when we say, well, we have this idea of perfect justice that we know we can't achieve, and we have an idea of procedural justice that we have to live with, the question is, what is it that we're saying to those people where we make mistakes? What are we saying to the offender and to the victim and to the citizens as a whole? And so one way to think about procedural justice then, and I think this is important because many of us in this field who don't have sort of a lot of technical training and economics and statistics and operations research and all that sort of stuff, they start with a really strong commitment to procedural justice as the place to stand on. And sometimes they defend procedural justice as a device for producing substantive accuracy. People will often make the claim that the adversarial system is the best thing we can do the best way we have of determining the real facts of a situation, all right? Now, my own view is that I'm not sure that's an accurate claim, but I'm being a procedural justice guy, and I don't plan to change that anytime soon, and I'm happy to live with that as at least part of the justification. But it seems to me that we have other justifications for procedural justice, which is that we want to have procedural protections as a device for protecting dignity and the rights of the accused, which I think is one of the great parts of the American criminal justice system. And I think that what this is based on, and I keep trying, is that every American knows that when the state comes after you, you need a buddy, right? And that buddy has to be a procedural protection and ideally a public defender, because the state can be a tyrant and it can be a bully, and we all ought to join together in feeling bad and trying to protect a person, not necessarily because we believe them innocent, but because when we find them guilty, we'd like to be sure we did the right thing. Right? So there's some part of that that has to do with simply protecting right relationships between the state and accused persons. Then the last procedural protection is a device for biasing the system towards errors of one type at the expense of the other. And I think that this is true too, but it's a slightly different claim than the first one. It says basically, in this system, we prefer errors of falsely letting people go rather than falsely convicting innocent people. So I want you to have a picture then of one way to think about the way we think about the current system, which is that we've got the traditions and cumulative wisdom of human experience that's grown up through the common law and through the development, and that's produced procedural justice, which is probably enough to control the rough justice that I described by the Philadelphia Police Department in the first moment. Right? If we merely did procedural justice, chances are we wouldn't have a cop saying you have to be a nullity to shovel society shit. Right? That would be a game. And I think an awful lot of excellent lawyering and a lot of professional training and stuff like that goes into using procedural justice to constrain rough justice in the pursuit of perfect justice. And if you stay within the legal world, this is what you've got to work with, it seems to me. But if we imagine then a slightly different trend that's taking place, which is imagine now that some technical ideas have shown up, and some of those technical ideas are ones that are focused on the accurate detection of crimes and offenders. And another part is focused on using managerial techniques to get more consistency and reliability in the development of these cases, hoping that if we can take some of the junk out of this, that we'll be able to get more reliable separation between guilt and innocence, right? Now, and that then is designed to produce the managerial things that help us with procedural justice. We've always struggled for procedural justice in police departments and prosecutors' offices and public defenders' offices and courts to sort of get those organizations to run in a way that was not only protective of procedural justice, but also consistent and low cost and efficient and effective and all that sort of stuff. And but we've also then developing managerial stuff with respect to the new techniques for producing substantive accuracy. This is the successful management of labs that produce reliable more reliable judgments of who's guilty and who's innocent. And we have the technical gains to produce accuracy. And that the red stuff then emerges as kind of a challenge to the blue stuff. And the question is whether the blue stuff can accommodate in a useful way the red stuff, right? And it seems to me that that's the world that we're here to address, is the degree to which we think there's potential here in the red stuff for moving the criminal justice system toward a more perfect justice system, going beyond the rough justice that we're able to produce. But the price is going to be to figure out what the hell this sort of stuff is doing to our understanding of procedural justice, and whether adequate protections are there as well, and whether they're aligned with one another or not aligned with one another. Now, most of my life is spent teaching people this particular diagram, right? And this we call the strategic triangle. I've developed it and presented it all over the world. But what you have to imagine is, here you are, you're sitting in this room today, and you are agents of the nation's criminal justice system, right? And so we could put you right in the middle of that strategic triangle and say to you, let's think about your strategic leadership challenge, right? And the first aspect of your strategic leadership challenge would be to identify the particular public values that you're trying to protect. And in some sense, what I did in the first part of the talk was to nominate for you these ideas of the values that ought to be the guide to your action in trying to improve the performance of the criminal justice system, right? And then you'd have to say, well, if I'm going to produce that set of values, including substantive accuracy, deontological values at the individual and collective level, and utilitarian values at the individual and collective level, I may have to change something in the way that I'm operating, the way the criminal justice system is currently operating, and particularly for this purpose, that the piece of the criminal justice system that's adjudicating cases that have been built. But in order to make that change, I'm going to need to build legitimacy and support, right? And that turns out to be, in many respects, the most important starting point for any successful effort in change in the public sector, is the building of political legitimacy and support for the change that you want to make. Now, because you are members of a profession that have a very strong position with respect to control over what happens in the criminal justice system, you are in a very powerful position to exercise leadership. And the good news about that is that if you decide you want to change, you probably can make it happen. If you decide that you're satisfied with the current system, then you can probably block anything that might be better. Right? So that's the dilemma that you find yourself in. And so the question is, I think, is whether you're going back to this question here, is exactly how we ought to explore and integrate these two worlds in an effort that advances the values that I think we all take seriously, including the people who do this work as well as the people who do the work on the blue side. And to conclude, in some sense then, to think about the strategic challenge you face, and the question is how in the world are we going to build legitimacy and support for a set of improvements in the operational capabilities of the criminal justice system to produce more public value. I'd suggest that these are the sources of legitimacy that you might be able to tap. And notice I put the biggie up there in the front because this is the one you control, the law, right? There's another one that's called expertise in science, and you have, of course, a great deal of expertise in the law and the way the criminal justice system operates, but perhaps a little less in either the managerial techniques that are associated with creating high reliability organizations, and a little less with respect to the science, the forensic sciences of one kind or another, that allow us to more accurately identify who was at a scene, how a person died, et cetera, et cetera. But I think the biggest challenge for you is going to turn out to be, again, you can make this an in-house operation if you want to, but I don't think it'll go very far if it's only an in-house operation. And the question about how to mobilize citizens and taxpayers and voters, as well as the clients of the system, to join you in an effort to improve the quality of the system is going to be the challenge of politics and building political legitimacy and support for the change. And the only way to do that is with a moral vision of what the important values are at stake that you're trying to advance through your creative leadership of the system. So with that, I'd like to conclude and welcome you to what I think is a stern test of a profession that has an interesting opportunity before it to both size up and exploit. So thank you very much.
Thanks, Mark. I really appreciate those remarks, and I think they do a great job of setting the stage for the conversations where we're going to have that. Where'd your triangle go?
It's everywhere. It's everywhere.
Because when we think about the policy leaders of the agencies that we'll be examining, of course, those policy leaders have to understand what is going on with the law, but also operate in a political world and have financial constraints, political constraints, and all of those things that have to be factored into the decisions they make as they try to achieve the definitions of quality that we'll be talking about today. And so understanding that larger perspective beyond the world of just the law as a source of legitimacy, I think is going to be really important in the conversations we're going to have. We're going to take about 15 minutes now, and then we'll come back and introduce the first panel. So we've got refreshments outside, and please mix and mingle.